us on mute.
Sharon, when you get most people in, let us know.
We're up to 63 and it's slowing down. So if you want to start, I'll keep my eye on adding people.
Absolutely, I'll go ahead and start. Welcome everybody to our Guardianship Seminar. My name is Karen Musembi. I'm the Chief Services Officer at the Red Gram Association. For those of you that don't know who we are a nonprofit organization in the DuPage County area. We support nearly 2,000 people in over 35 locations in DuPage County. If you would like to learn more about our services, please fill out the link that will be sent in after the survey, and we'll be more than happy to connect with you afterwards. Today we have two outstanding presenters, and we are delighted to be able to offer these opportunities to you. Before we start, there will be some links that Tara will be sending at the beginning and at the end of the survey, if you can complete those. For those of you that are looking for CEUs, we'll also be sending you a Survey Monkey, if you can complete that so that you can receive your CEUs. We are also going to be taking all questions on the chat function. And at the end of the session, Sharon Anderson, our Quality Enhancement Manager, will be facilitating that. We are also going to be recording this session so that we can make it available for other families that are not able to be here today, so just so you know that. And we'll also be sending you the slides that Benji will be using to present. And if you want to connect and have any further personal information that you need to connect with him on, you can have all the contact information. So with that being said, I would like to introduce Tara CONLEY and Benji Rubin to provide the presentation for this afternoon. So welcome.
Thank you, Karen. So we're going to tag team this where I'm going to start at the beginning of the presentation and go through details about guardianship and the process, more technical things. And then Tara's going to talk at the end about sibling support and sibling perspective on things. All right, so with that, I'm going to share my screen. All right. All right, so first, a quick introduction. I apologize. I tried to fix this during the break, but I wasn't able to, so there's no music. All right, so it's a quick background about me. You know, my brother Mitch is the reason why we practice the type of law we practice, and why, and you know, so personally, professionally, so much of my life is dedicated to this area. Working with people with IDD. So my brother Mitch, he is now 40 years old, and he lives in a group home run by Clearbrook, another agency in Illinois, similar to Red Gram Association. And he, as you see, before the pandemic anyways, he came in once a week and did some shredding for us at our office. And has been managing pretty well considering with everything that's been going on with COVID. All right, so that's Mitch. A little bit about being a sibling. You know, it helps put things in perspective in life, you know, being a sibling, but it's different than the parent perspective. So, you know, being a younger sibling, you know, I have no concept of what it's like not to have a sibling with special needs. You know, parents have a whole life before they have children and have a child who has IDD. You know, siblings are born into it, or even if they're older sibling, you know, it wasn't many years before they had then had that sibling with disabilities. And so that's something that really impacts so much of our lives. It impacts the friendship, you know, our friends that we choose to have. We tend to be more mature than our peers on average, not always, but on average. And throughout you know, childhood, we see kind of just different types of you know, patterns and different kinds of you know, activity ways that they interact with their siblings. So you know, there will be periods of time where a sibling may be feel jealous or resentful of their other sibling. They may feel very protective of their sibling with disabilities. They may feel embarrassed by their sibling with disabilities, and that's fine. That's okay for them to feel all of those different feelings and emotions, and it's really important to validate whatever feelings and emotions they have at that time. You know, vacations were an adventure with my brother. They were not relaxing by any means. And that's just something that my parents tried to acknowledge by, they took opportunities to have one-on-one interaction with my sister and I, and one of three, an older sister. And a couple of times when my brother was growing up, he had an overnight camp experience. And during that time, he went to an overnight camp with a one-on-one aide. For that, you know, 1 to 2 week period, my sister and I would go. My parents took my sister and I to on a trip for that week or whatnot, and we were able to have this quote unquote typical family vacation where the focus was entirely on us and not on my brother like it always would be when we had we had the normal family vacation. So just things to think about, food for thought. You know, growing up, again, talk about embarrassment, trips to the grocery store, my brother would have a meltdown in the middle of the grocery aisle. Now, hopefully there's less, there's less comments and staring that occurs now than it did then, because back in the late 80s and early 90s, there wasn't as much awareness about things like autism and behaviors in children that maybe are too old to exhibit those kinds of behaviors. At least that would be expected. But the biggest thing that we as siblings have is understanding our future responsibilities that we have in common. Knowing that it's very likely that our brother or sister is going to outlive our parents, and sometimes it's going to be there for us at some point. It's going to be there that we're going to have to take over in some capacity. One of the big capacities that might be is this guardian, which we're going to talk about for the rest of the presentation. But it's really important to know that including siblings as early as possible at age appropriate in an age appropriate way is super important. Studies have shown, and Tara can attest, that children as young as 8 or 9 years old are thinking about what's going to happen when my parents die and what is my role going to be with my sibling. And so to the extent that we can help alleviate concerns and fears they may have and give them a better understanding and have them participate in what that future might look like, it's so important for them. So please do include them in that process at an age appropriate level. Don't leave them in the dark about it because they are thinking about it. You're not protecting them by not talking about it. So I'm the president of Supporting Learner Brothers and Sisters. And again, I'm going to leave Tara, our founder of that organization, to talk more about it at the end of the presentation and talk more about the national organization, Sibling Leadership Network. All right, so guardians are nominated in the parents' wills. So what does that mean? So when the parents draft their wills or an attorney drafts their wills for them, in Illinois and in many states like it, this is your opportunity to nominate who will be guardian for your children, of course, minor children until they're 18, but also a child who's going to need a guardian as an adult, okay? And it's not binding on the judge as to who will be guardian when you're gone, but it's very persuasive, okay? Of course, if the judge finds out that this person has skeletons in their closet, then maybe they don't appoint them, but generally they're going to accept whoever the parents appoint in the will. Now, when a child turns 18, no matter what the nature of their disabilities, it is presumed that they are a legally competent adult in the eyes of the law. And so what does that mean? It means they can sign things, they can agree to things, they can do anything really. They're a legally competent adult in the eyes of the law, like I said. So when it comes to, give me one quick second, I apologize. And from home and all that. When it comes to, when it comes to, a process of guardianship, it's that a judge has to determine that the person does not have capacity. Okay, because when they turn 18, again, it's presumed that they do have capacity to make all kinds of decisions as an adult, just like any child who turns 18. So first, we have to see, can they manage their own personal, medical, education, financial decisions? All right. And what's going to get in the way of that, of them doing those things? Could they be vulnerable to themselves or other people? Could they be taken advantage of by others? Those are concerns that people often voice when they have a child with IDD. So, the day a child turns 18, when it comes to schools, they don't have to talk to you anymore. In fact, they legally cannot talk to a child who's now 18, unless something's done. Doctors or hospitals, they're not going to want to talk to the parents anymore. They're going to want to talk to the child. They're going to say, we have to talk to them. When it comes to signing contracts or documents, they can do that on their own the day they turn 18. You want to apply for SSI and Medicaid, they have to be there to do the application. They have to fill out the application themselves unless you do something. They have to sign it anyway. Residential living arrangements, that's up to them to decide unless, again, we do something. Employment, day programs, job coaches, all that stuff, all in their realm of decision making. Deciding to get married, driving, if they're arrested, God forbid, and get themselves into the criminal justice system. This is, if there's no guardian, even if there is, it's not diplomatic immunity, but if there is a guardian, it could be helpful. And in that situation where they were, God forbid, arrested. So, maybe because of something that they don't really understand, like my brother pulling a fire alarm. He was put in plastic handcuffs once. They didn't actually fully arrest him, but they were on their way towards that. Even though my brother has severe autism and it is identifiable to any person within a second or two of meeting him, they still did that. So, these are reasons why guardianship can be helpful. And again, it's not something that'll actually prevent them legally from doing some really ridiculous things, but it's probably going to stop them from getting too far with it. Okay. Now, what are the options when the child turns 18? Well, we always want to start with the alternatives to guardianship in terms of considering what our options are. So the first option is always an option, which is to do nothing. There's a law in Illinois called the Healthcare Surrogate Act, and it says that if a child does not have a guardian, but they can't make informed medical decisions, then if they're not married and they don't have any adult children, then either parent can make medical decisions for them. Okay, but it's only if the doctor or hospital agrees they can't make their own medical decisions, and it's only about medical decisions in particular. So they have to lack decisional capacity. They can't have a power of attorney in place, which we'll talk about. And then again, the order of who can make those decisions, it's if there's a guardian, of course, there wouldn't be in this scenario. They're not married, they don't have any adult children, either parent. And guess what? When we talk about siblings, if the parents are both deceased, then the siblings would be next in line, but it's whoever's there. Any sibling has equal standing. All right. So the first thing, and I know that Tara's gonna talk a little more about it, but supported decision making. That is like the kind of least restrictive step. Okay. That is, this is an individual who is very, very independent, very self-sufficient, but needs some help. And this would be giving mom or dad usually, or a sibling, authority to help them with things, not even help them with things, authority to get information about things, to talk to a doctor, to talk to an employer, to talk to school, to deal with Social Security or Medicaid. Basically give authority to get access to information, but it doesn't give you authority to even make decisions on their behalf, let alone take away their right to make those decisions. The next step, and it's a step we usually end up taking, is to have the individual with disabilities sign powers of attorney to mom or dad or a sibling, if that's the case, to give not just access to information, but also to give authority to make decisions on their behalf. Okay, but powers of attorney are not taking away their rights. Okay, it's a document that they would sign that gives authority to someone else to do things on their behalf, but they can always revoke that authority at any time. They still retain that control. So there's one for financial or property matters, one for medical decisions, one for mental health treatment, and one for special education. Social Security and Medicaid have their own forms as well. But do they have capacity to sign a power of attorney? That's a question. They don't have to have this beautiful cursive signature. They can print their name on it, and that's good enough, as long as they understand they're giving the mom or dad or their brother or sister authority to make decisions on their behalf. Okay, that's the important part. So there's the power of attorney for property. We want to add a lot of extra powers to that power of attorney, because if you go online to get the statutory Illinois short form power of attorney for property, it's not going to include all the powers we'd want the family member to have on behalf of that individual with disabilities. Dealing with government benefits, dealing with tax matters. Tax matters come up a lot. And obviously in most cases, they're not capable of handling those matters, or even engaging an accountant to help with those matters. So, for example, if they have a special needs trust, they're going to end up having to file tax returns based on in-kind distributions, money spent for their benefit. There's a lot of things that come up you would never think would come up with the IRS when someone has intellectual developmental disabilities. So that's an important one to have as a power of attorney. Residential matters, dealing with where they're living, employment matters, job coaches, funding a first-party special needs trust, which is a topic for another day, or dealing with ABLE accounts on their behalf, another topic for another day. A broad HIPAA release to get privacy of medical information, all that stuff. And then passwords, usernames, user IDs, authority to get all that information as well. And then something that says that copies of a power of attorney are as good as the original, because the statutory form doesn't have this, which means that if you go to a doctor or a hospital, or even a bank, or any place that you need a power of attorney for, they're going to say, we need this original because we can't accept anything else. So we have language that says a copy is as good as the original. And so they have to accept a copy, and you can retain that original as the agent. The medical power of attorney is pretty straightforward. It says that you can make medical decisions on behalf of that individual. Okay. There's also a mental health treatment form, which is, we call it the scary form, because it talks about electroconvulsive treatment. It talks about involuntary admission to psychiatric hospital. In fact, it's more powerful than a guardianship in many ways, because most of these things you cannot do without further order of the court, even if you are guardian. Whereas this document, if it's signed, does allow those things: 17 days involuntary admission, electroconvulsive treatment, etc. Even though, again, a guardian would have to get court approval for these things. Because it's so strong, it requires re-signing every 3 years. It expires automatically every 3 years. And it also has a provision that you can have a doctor have to sign off on any decision made in addition to the agent, that may be mom or dad or sibling. Special education power of attorney, that went into law in 2007 because school districts weren't accepting any other powers of attorney. And this has to be renewed annually, every single year. So most powers of attorney, they go on forever once they're signed. Special education power of attorney, every single year you have to re-sign it. Social Security and Medicaid have their own forms. All right. Now, do they have capacity to sign the power of attorney is a question mark. And will they allow you to, or will they actually sign the power of attorney? Will they allow you to act on behalf of them even after they sign it? Will they void it? They can void it even verbally, as we'll talk about. It doesn't prohibit them from being vulnerable to themselves or other people. All right, so what could go on? They can go on, mom or dad's iPhone or their own iPhone and start buying things, okay? And, how do we get out of that? Once they start buying things or, buying in-game purchases or whatnot, what do we do about that if they don't really have capacity to understand what they're doing, but they do it anyways? What if they announce that they're getting married or moving in with a friend? I don't know if that's a realistic possibility with your family member, but that's a concern because if you're not guardian, they could do that. Here's a concern. A less than reputable school district tells the child, you do not want your parents coming to that IEP meeting about you next week, right? You don't. And they shake their head no. They can verbally override a power of attorney, even without anything more. They don't have to sign anything. They can just verbally override it. So because of that, there's a concern they can be vulnerable to being tricked by other people, including a situation where all of a sudden there was an IEP meeting 3 weeks ago and you don't hear about it because they were tricked into telling them, no, don't invite my parents. Driver's license test, they go get a driver's license test, even if the parents don't want them to, assuming they get past it, I don't know. And then there is, them being asked to sign something at work or at school or wherever they might be, and it's legally binding upon them because there's no guardian. Okay. So what if they won't sign a power of attorney or they can't do it because they don't really have capacity, or we've determined that, you know what, it's not enough. They're too vulnerable. Then we look at guardianship options, okay? So what are the options for guardianship? There's a limited or partial guardianship limited to certain areas of their life. Maybe they can't sign contracts, maybe medical decisions, maybe employment decisions, but at a certain point we have to give them authority over certain other areas. Otherwise, we've turned it into a plenary or full guardianship. If we do a limited guardianship, we may do powers of attorney to cover the other areas that aren't covered by limited guardianship. But with a plenary or full guardianship, they are effectively 17 again. Oops. So that is something to be aware of. Okay. The guardian has legal authority to make decisions on behalf of the ward, which is the technical term for the individual with disabilities. Okay. Of course, the judge has to find they don't have capacity to make their own decisions. It is a very protected process because we're taking away someone's rights who's presumed to be competent in the eyes of the law. So the first thing is, who can be guardian? They have to be 18 years old. They have to be a legal U.S. resident. Okay, they don't have to be a U.S. citizen. They have to be a legal resident, their green card, for example. They cannot be undocumented, obviously. That's not permitted. But they could be live in another state. They can even live in another country as long as they're a legal resident of the United States. They cannot be of unsound mind themselves or judged to be disabled themselves. And they cannot be convicted of a felony. A judge can overrule this in certain circumstances, but generally they're not going to. If they're convicted of a felony, generally they cannot be a guardian. And further, an organization can act as guardian of the person or a state for the individual if like family won't act or cannot act. Okay, so all right, which county do you go to? Well, if everyone lives in the same county, it doesn't matter. But what about if the individual with disabilities, again called the ward in this circumstance, lives in a different county than the parents? Well, then it's actually the county where the individual with disabilities lives. That's the county we go to have the guardianship proceedings started. Notice has to be given to everyone of equal or greater standing to the person who's petitioning for guardianship. So so for example, interestingly enough, if the parents go in for guardianship, you think, well, who has better standing than the parents? Well, actually adult siblings, even half siblings, have equal standing to the parents for whatever reason. So we actually have to give notice to adult siblings. So if the child turns 18 and they have an older sister or older brother, that older sister or older brother has to get notice. It's just a formal legal thing that has to be done, but it has to be done. All right. Or an ex-spouse, obviously would need to get notice as well. Now, there has to be an Illinois licensed MD who has to fill out a report saying that they need a guardian, and if it's a limited guardianship, it has to be very, very specific as to which areas they need a guardian over. This one has to be done within 90 days of the court appearance. They say date of filing, but usually they actually want it within 90 days of the court appearance itself. So we really don't want to start that process of the doctor's report with it more than like 60 days out generally to be safe of when the child's turning 18. They have to be served personally. This is now permitted to be done by an individual. That doesn't have to be by the sheriff's office. We used to do a field trip to the sheriff's office, but this is something that either the attorney you work with for the guardianship, or if you do it on your own, the clerk's office can help you with. You have to set up a time to be served, to have the child be served, handed papers. Literally, they just have to hand them papers. You see this in the movies when you're being served. It's the same concept. Guardian ad litems. This is something that a judge can appoint to see whether or not this individual needs to have a guardian, basically, to investigate it. Most counties don't require this. Even McHenry County, which used to require it, no longer does. You know, in all the other Collier counties, Cook County does not require it, so long as the individual with disabilities and the individuals, of course, who want to become guardian, all are going to get to meet that judge. This means virtually currently, but in the future, again, may mean in person. Okay. And if you have to have a guardian ad litem appointed, by the way, they will be paid by the person who's petitioning. So the parents usually are going to have to pay, in addition to paying for their own attorneys, maybe. When do you have to go back to court after doing this court process of becoming guardian, which again is being done virtually right now in most counties, but could be in person in the future? You know, when do you have to go back to court? A handful of times throughout their life, but we do have to do annual reports once a year. If you don't file them, you'll get a really scary letter saying you're going to be held in contempt of court and they can send you to jail. So don't do that. Send in the annual reports once a year. No one really gets sent to jail, but they do send you a scary letter and you better file it soon. Otherwise, they will start sending even more threatening letters, and at some point, they may take away your guardianship, basically. So you're going to want to make sure you file them. Now, Cook County is the one county in Illinois that doesn't follow Illinois law. So go figure. They require filing online and via mail, whereas every other county follows Illinois law and says you just need to e-file it. You have to file it online, the annual report once a year. It's a simple form. It's not that big of a deal. And there's instructions that are on our website if you need them. Now, when do you have to go back to court other than, again, I said you have to file an annual report, but when do you have to go back physically to court or virtually under the current circumstances with COVID, is if they're moving into a group home, for example. That's one of the handful of times throughout their life that a judge needs to approve it. And so if they're moving to group home, that needs to be approved by the judge. Some agencies are not aware of this. Some judges aren't even aware of this, but it is very clear in state law that it's required. If you want them to have their tube-side vasectomy, this is obviously a very sensitive topic. It's considered a very fundamental right in the disability community, and so, and just in general, and so they require this be a court order if it's requested to be done by the guardian. When it comes to medical decisions under the Healthcare Surrogate Act, as we've already gone over, guardians are number one to make medical decisions for the ward. And that means that they can make all medical decisions, including end-of-life treatment, with a handful of exceptions, which we've really already gone over. Electroconvulsive treatment, involuntary admission to a psychiatric hospital, and I apologize for going over these kind of not with the emotion that they deserve, but also, as I said, having reproductive rights limited. Those are the things that require further orders of the court. Otherwise, including end-of-life treatment, a judge can make those decisions. Or excuse me, a guardian can make those decisions without a judge's approval whatsoever, including end-of-life treatment, like I said. So that's a pretty powerful that a guardian can do those things without court involvement at all. Now, if the individual with disability signs something and they have a plenary guardian appointed, even if it's just to the person only and not of the estate, which is over money, if the child had money in their name, then they will basically, it's voidable. I mean, they can sign a contract. It doesn't matter. If the guardian didn't sign it, it doesn't really matter that they agreed to it, unless the guardian have signed it as well. They can still vote, though. We are one of a handful of states in the country where a ward, an individual who has a plenary guardianship established over them, can still vote. Okay, probably do a better job than we've been doing anyways. But we're a handful of states that allow that. Not surprising considering people, dead people vote in Illinois. So we are very, very liberal with our voting policies. Now, driver's licenses. This is a very important thing to know. You cannot have a driver's license if you have a guardianship appointed over you, a plenary guardianship. It is a big problem when they have that. You could be sued if they got into an accident as guardian for them because you were negligent allowing them to get a driver's license when they were not permitted to. So plenary guardianship and driver's licenses do not mix. Limited, as we'll talk about, is permitted to have driver's license. Okay, limited guardians. Another thing to note: a limited guardian doesn't constitute legal incompetence, which means if they fill out a job application, they don't have to check the box that says they've been declared to be legally incompetent. They can say that they don't have to say that. But if they have a plenary guardian, so if this is something that's of worry, then we would want to stick with limited guardianship. Being a guardian is a big job. It is being on call 24/7, 365. Could they be liable if they hurt others or hurt property? Potentially, probably not, especially if they're at a group home or they're in a licensed agency. But if they're on their own in an apartment or living with the sibling or with the parents and they hurt someone or damage property, absolutely the guardian could be held liable for being negligent and allowing them to be unsupervised in that situation. They can limit liability potentially by getting a limited guardianship, limited to certain areas, because then you'd say, hey, I'm not guardian over their entire person, I'm just guardian over certain areas of their life. Also, they can the family could hire a nonprofit organization or a for-profit organization, whichever makes sense, to actually act as guardian in place of them, and they would take on that liability because they have insurance. What if no one will act as guardian? Then we get to the public guardian's office, the state public guardian's office, or county public guardian's office in Cook County, or a nonprofit organization, again, if the family or someone's going to pay for them to act, or a special needs trust will pay for them to act. When it comes to guardianship or guardians who could be appointed, they could have co-guardianship. In most cases, parents are co-guardians for their child. Okay, if they're divorced, it's up to the judge if they think that's okay. If it's siblings, generally not more than two can be co-guardians at the same time. But we are allowed to have two, but co-guardians is very common. Some agencies, the law is somewhat unclear about this. Some agencies or doctors or hospitals want both people to agree as guardians or sign off on things before they'll say that the guardians have done it. To cover their bases, I think that's the best probably thing they should do, but that's their problem, not yours. If you're the guardian and they just take one signature, that's their problem. If they want to cover their base and take both. If they just take one, you don't have to tell them, hey, you should take both. Just let it be. It doesn't hurt you at all that only one of you signed it. Okay, now when it comes to short-term guardian declaration, this is a form, a document that allows for a temporary delegation of your guardian responsibility to someone else. So when my parents go out of town, so maybe they both been vaccinated now, so maybe in 6 months or something, they're going to go on vacation, and they will delegate to me while they're on vacation guardian responsibility for that week. Okay, they fill out this form and they can fill it out as needed. It can only be done up to 60 days within a 12-month calendar period. Though there's no guardianship police out there, so no one really knows how much you've used it, but that's the law. Moving out of state. If you move out of state, you have to transfer if you move out of state in terms of mom and dad or siblings, that's not the issue. If the individual with disabilities moves out of state, we have to transfer the guardianship to the new state. But it's up to the judge. It's up to it's a whole process. Some states you can transfer it. Other states you have to actually start anew. It depends on the state. Most states now, like 40 some odd states now, you can just transfer the guardianship out of Illinois to the new state. Moving out of county, it's up to the judge if they'll require you to change the county that the guardianship's in. Some parents, siblings, again, will decline to become guardian because they're worried about liability, being sued, or being negligent in a situation where they hurt someone or other or property. And then we go to either a state public guardian's office or the private agency being paid by the family to act as guardian. Since 2018, it is required that all guardians do an online course. It's a few hours. They have to sit through and watch this online course about becoming a guardian. Now, there's one county in Illinois that's exempt from this requirement, and that's Cook County. And that is not because people are smarter in Cook County. It's not because people know more in Cook County. It's because of politics, and that's typical Illinois. It's pretty embarrassing, but that's Illinois. I will, and I forgot to ask from the first session, if I had emailed Karen this, if she had it from previous presentations, But this is a information request form that you can check the box for more information about different topics that we did not cover today, that we also will be covering in future presentations. We're doing a presentation on behalf of the ARC next week, for example. So that'll cover a lot more of these topics. There's actually other speakers at the ARC presentation next week that'll also have more topics covered. So if you want more information, just reading material about any of these topics, you can get this from Ray Graham. Will send this to you, and you can check the box for more information about those topics. All right. Having said that, I want to turn things over to Tara. And actually, before I do that, one other thing I wanted to do is, let's bear with me one thing. Let's see if I can find this here. Is just a couple of notes about things that have changed recently with regard to guardianship topics. One is healthcare powers of attorney. If an individual has a healthcare power of attorney and then the parents or siblings become guardian for them, we actually have to revoke that healthcare power of attorney. So that needs to actually happen legally before the guardianship can be put in place and take over. County, the judge currently in place there does not like limited guardianships. They're very opposed to limited guardianships. So just be aware of that if that's what you're seeking there. McHenry County, until recently, they would not, they required guardian ad litem to be appointed, and they were often $1,000 or more that they would charge the parents who are becoming guardian or the siblings becoming guardian. They no longer are doing that, basically. They're requiring only that the individual with disabilities and the individuals who are petitioning to become guardian show up to the court hearing or to the online court hearing currently, and that is enough. No more guardian ad litem in McHenry County. There's a new judge in DuPage County. He seems to be Judge Oro. Seems to be not or a little bit more strict in terms of just procedure and stuff than the other judges previously have been. Also, he calls cases in the order that of when they started. So the oldest cases get called first, which means new guardianship cases get called last, which means you may be waiting a long time to get heard. Which is a little frustrating for many of the individuals we're talking about, because oftentimes them waiting is very difficult. Something called ABLE accounts, which will be presented about all the time, and there's plenty of times where you can hear more about ABLE accounts, or you can get more information about ABLE accounts if you check the box in the information request form. The guardian of the person, since we got the law changed, we actually lobbied for this and it helped write the legislation. We amended the Illinois ABLE Act so that we can now actually the enabling legislation for Illinois ABLE, so that we can now actually have the guardian of the person be in charge of the ABLE account, not only the guardian of the estate. And finally, a private individual can do the service of process, a service of summons, where they're handed the paperwork to the child, not just a sheriff's office or an official process server. So that's a change that happened recently. So those are some updates with guardianship. Now with that, I want to turn it again, like I said, over to Tara to talk about the sibling perspective on things. So thank you very much, and I'll be back to answer questions.
Thank you, Benji. Once again, so much information. I know it's really hard to wrap our heads around all of that, all of this information, but hopefully it makes sense to people depending on your person that you are looking at guardianship for. I am glad to answer any questions too about guardianship. If you're a sibling, I can help you walk through what you need to do in the future should that ever come up. So like Benji said, I'm Tara CONLEY. I am the independent consultant for supporting Illinois brothers and sisters, and that has been made possible from an investment from the Illinois Council on Developmental Disabilities in partnership with the Sibling Leadership Network, which I'll talk a little bit more about that network in a little bit too. Wanted to give you a little bit of background about myself, just so you know where I'm coming from and what my experiences are. Actually been in the field of intellectual and developmental disabilities for a really long time. Started as a support worker, a respite worker with an organization many years ago. So I've been in the field for over 30 years. Of course, I'm a sibling. I have a younger brother, Nick, with developmental disabilities. And I first started, besides being a support worker, I was a QIDP. We used to call them QMRPs, Qualified Mental Retardation Professionals. I'm so glad the state finally changed that to Qualified Intellectual Disability Professional. Did that role for about 10 years, met many siblings and parents and learned so much. Actually, I think at that time I met the Rubens, so I was getting information about guardianship and what that all means and how to help families work through that information. And then I became an individual service coordinator, and I did that for another 10 years, so an ISC. And I want to give a shout out to Ray Graham and thank them for giving us this opportunity. Benji's information is really important. I think my information is really important to talk about brothers and sisters. Not everybody always does, so I really appreciate them inviting me to talk about SIBS and sibling concerns. I have a long history with Ray Graham. Actually, my brother received services from them for a number of years. They, back in the day, allowed me to run some Sibshop programs in the basement of their building in Burr Ridge. And hopefully maybe someday we can do that again. It wouldn't be in that building, but maybe. Somewhere else. Let me just explain what Sibshops are, because I think there's some older families, or maybe there's some younger families that might be beneficial for. But that's a program for young brothers and sisters from about the age of 4 to up about the age of 18. Not together, but in different separate programs, are a curriculum sort of based program. It's not school, it's all fun, but it gives brothers and sisters, young brothers and sisters, the opportunity to meet one another and to know that they are not alone in their situation. And it's really a place that they can talk about their concerns and needs in a safe, welcoming, fun, recreational kind of environment. And over the years, what we have found is that those siblings that have gone through programs such as that tend to stay more lovingly involved in their brother and sister's lives in the future, which is why we are always talking about future planning and guardianship, because we want siblings to be in those roles if they want to be and if they feel comfortable. And part of our job is to help people through, or help siblings through, that process. Okay, with that said, let me talk to you all about a little bit about SIBS and who we are. Our mission is to provide support to siblings of people with disabilities in Illinois by connecting them with information, networking opportunities, and resources in order to enhance the quality of life for their entire family. So when we think about the organization itself, we're not just looking at serving siblings. We're looking at supporting their brothers and sisters and their parents and giving information to providers. We want everybody to come together and be on the same page, in a sense. So Catherine is from Ray Graham on the call, and we used to work together. I think she reminded me that it was like 20 years ago. And it was at that time that the idea of SIBS was really born. So we're talking 20 years ago, but SIBS became first incorporated in 2007. And that all happened because of networking with other brothers and sisters and finding a true group of folks that had the same vision and dream as mine. And so we started that process. And at this point, we have more than 500 members, well, more than 500 members across the state of Illinois. And those do include adult siblings, parents, professionals, and really anybody who has the desire to support brothers and sisters' needs. So we welcome all of you here to join us in that mission. And one of the ways you can do is by going to our website. And Benji, I'll go ahead and let you go into the next slide. Maybe.
Sorry, hold on one second. There you are.
So this is a page that you're going to see when you go to our website. If you click on the little, it might be hard for you to see, but the little house, it's the home button. And if you scroll down, you'll be able to find where to join to get our newsletters. And just to be aware, you know, we don't send a ton of stuff. It is all sibling related, whether it be a Sibshop, information for adult brothers and sisters, or even things that parents and professionals can attend to learn more about the sibling experience. There's a ton of stuff. You guys don't really always realize how much information there is about and for siblings. As we've gone into this sibling movement, really started for us in 2007 with the Sibling Leadership Network, which is basically, think of the arc of the US, let's say the arc of Illinois is a chapter. So the Sibling Leadership Network, we are Illinois' chapter, if that makes sense, hopefully. I'll talk a little bit more about them a little later as well. Just want to make sure you guys all understand we welcome any sibling, no matter what their sibling disability is. So it could be a developmental disability, intellectual, physical, it could be a mental health concern. We even want our brothers and sisters who have had a sibling pass away, stay with us, or even join us if they have never done anything with them or with us in the past. One of the things we are starting to do now is run groups for siblings that have, or a peer group for siblings that have a brother or sister that have passed. And we are learning that that support is just as important as supporting their siblings that are still brothers and sisters that are still here. Like parents, where sometimes, you know, sibling concerns have always kind of mirrored our parents. They also mirror when your brother or sister passes away. So there's that commonality. But what we have seen is that siblings are getting pushed in the background. So not pushed, but the parents are, their grief is addressed more either sooner or more than the siblings. I think somehow people forget that the siblings are hurting as well. Okay, let's see. Okay, so talk a little bit about what we have done, and in the past 12 years when we didn't have funding. So now we have funding thanks to the investment with the Illinois Council on Developmental Disabilities. In the past 13 years, we pretty much have only been a board run. We're all volunteers, nobody gets paid. But thanks to ICDD, we've been very lucky that I have been able to be in the consultant role, kind of helping take the lead and develop programs and move us really forward. We have been kind of in limbo for so long, doing tons and tons of stuff, but have been in limbo. So some of the things that we did before we had any funding was we hosted adult sibling gatherings or meetings back in the day. Those were in person, and so they were a combination of social outings, and sometimes we would have speakers come on different topics, such as Benji would come and talk about guardianship, or many other things that he knows about. We'd had somebody come talk about housing. We had someone come and talk about services and how services in Illinois works. And then we have hosted a Sibshop training program. 3 times we partnered with other organizations in Illinois to bring the trainers here, because in order to be a trained Sibshop facilitator, you have to be trained by the organization called the Sibling Support Project. They are the ones who created the program, and they want to make sure everyone is trained in a specific way, which I give them all the credit for, because it's a very well-rounded, thoughtful program for young brothers and sisters. So we've done that. We've hosted several adult-only sibling conferences where we've been able to network with other adult sibling across the state of Illinois. We haven't done that in some time, so I'm suspecting that that will be coming up soon. And then, you know, I did get off topic, Benji, so I want you to go back to that, or go to the next screen. So this is the resource section of our website. Just wanted to note that there are a couple of future planning information in there for folks. And then also wanted to point out too, that in the events section, if you're ever interested in what we are doing, you'll see what's coming up next, and we are always updating that frequently. Okay, let's see. Well, that's what we've done in the past. So our website that you see there is something that we were able to utilize our investment from to really enhance and update. So it looks much better than it had been, and there's many more resources on there than we previously had to December 19th, which is when we started our investment with ICDD. We've created and updated a new brochure, which is much better than what we had before. We've created, as you can see, lots of resources. And then we have done the adult sibling gatherings too, but then we have transformed them into our virtual groups. Had COVID not happened, we would have still been doing them in person. But in all honesty, COVID was a good thing for us, because that allowed us to connect more with siblings all across the state, instead of where most of us are located in the Chicagoland, northern, western suburbs. We also, within our funding, had hosted, 2 other sibling workshops. So one of our goals as an organization is to get more Sibshop programs out there throughout the state of Illinois. We have about 20 in the state of Illinois, but they're mostly northern and western, a little bit in the south. We wanted to see more programs pop up in central and southern Illinois, hopefully soon, because we had over 100 people at one of the training programs. So hopefully we'll start seeing those pop up. Some of the other things we were able to do is we were able to create a really good strategic plan for our organization with our board members, which is helping us guide us in the direction that we want to go. And I'll be honest, anybody ever has any but suggestions and things that you'd like to see us do, please let us know. And we've continued to present at different conferences, which one of the ones that's coming up is the Arc of Illinois, which Benji will be there. And then we will have a sibling panel talking about how we survived COVID with our brothers and sisters. So Benji, go ahead and go to the next slide. Thank you. So when Ray Graham approached us or approached me in the beginning when talking about guardianship, I was like, well, you know what? I do know a lot about guardianship, but I don't know as much as Benji does. So I have to ask him. He's going to be able to explain all of these different ins and outs than I could ever possibly do. So when we thought about that, Benji could do his thing, allow me to talk about siblings. And then I wanted to talk a little bit about supported decision making, which is an alternative to like full guardianship. But mostly because it can be a good pair with full guardianship or any other types of guardianship, because really what we want to do overall is make someone as independent and self-determined as possible. Okay, so what is that anyways? It's the process of supporting an adult with disabilities to make his or her own decisions that foster the person's self-determination and does not take away their rights. So many of us here probably may not fall into the category of having siblings or adult people that can have complete ownership of their world. But if you do, this is why I want to have this information. And knowing that the concept of what decision-making, supported decision-making is really can be utilized within all of the guardianships. So think about ways parents who are on the call, adult siblings, even providers can support individuals with disabilities to make decisions for themselves. Again, right? That's the goal. That's what we want to do. Go ahead. Thank you. You're almost there, Benji.
Sorry, 1 second. My screen just, where did you go? There it is. Okay.
Thank you. So just a couple of things about resources and supported decision making. I wasn't going to go into all the detail of each one of these things, but I wanted everyone to have these resources just in case it made sense or you just wanted to investigate what it is a little bit more. So the first thing on there is the sibling survival guide and the chapter on future planning. I am going to show this book because in the first session, I let everybody know that if you email me, I have some copies that I can provide to folks. So it's going to be based on first come, first serve. I don't know how many I'm going to have, and I will communicate with all of you whether you can are able to get a book or not. But I wanted to let you know that this is a really good book for not only adult brothers and sisters, but providers and parents as well, to really understand the system. So it kind of looks at the system and how things work, Social Security, guardianship, through the sibling eyes, but it's very, very detailed about really everything one needs to know about supporting someone throughout their lives or in the future. We will get to my email just in case anybody wants that book. So the National Resource Center on Supported Decision Making. This is just the website that gives you more about what exactly is that, what does it really look like. I wanted to add the sibling role, because if you're a sibling and you want to learn how to support your sib better in making their own decisions, and this is a good presentation to take a look at. Just another resource on what supported decision making is, the Autistic Self-Advocacy Network. Want to point out the ARC Center for Future Planning. This is the ARC of the United States. This is a great, and the web address will be on the next slide, but this is a great site. It has lots of information. It talks about the decision-making supports for people wanting to do the supportive decision making thing. So it kind of walks you through things that you need to have in place. So there's that. And go ahead, Benji, to the next slide.
There we go.
So these are 2 more resources. Now, My Voice Counts is really a book for individuals, self-advocates, people who really want to be in charge of making their own decisions. And of course, these are for people who can do that, of course. So the guide has 5 different areas that the individual is going to go through with their potential support person. So it goes through understanding supported decision-making as an alternative to guardianships, and what does that look like? How to organize your ideas about what you would like to do and what you might need in order to make those decisions on your own. And then, of course, you need to have a team of people. So you want to, how are you going to choose the right people to be part of your team to support you in your decision-making? Then of course we can't do anything without some sort of agreement, right? So Illinois, we don't have technically, and Benji will correct me, but we don't technically have a law, but we have an act about Illinois Supported Decision-Making Act, and it does reference needing a certain kind of agreement. Again, I believe that there is no legal thing with it, but in the agreement in this book, it does, talk about like you can kick out your support person and get a different support person, but it really lines out everything that that person wants and needs help with, doesn't need help with. So again, it's a great resource should you be interested in learning more about supported decision making. The right fit is going to help folks figure out, is this even anything for me? Like, does some people are going to be on the border like, well, they're really good at making healthcare decisions, but they're not so good at making good social decisions. So this is a good guide to help kind of walk folks and families and siblings through, is this going to work out? Is this anything that I can even think about? Okay, Benji, go ahead. So even though there is agreement in that previous, the booklet, this one is from the ACLU, and it's another example. It might have been what Benji had shown in his slides too, but it's just another example of what a agreement could look like. You can build your own. You can take from the one book and this one and kind of combine things or take some things out that makes sense. Again, the next link here is the self-assessment tool. So this is really for the individual, right? Does this make sense to me? Does supportive decision making make sense? Or do I really need a guardian? Or do I need limited or a power of attorney? So it really helps families and people and siblings make that decision together. And again, I want to bring it up because there's some really great things within supported decision making that can just complement any type of guardianship that is necessary. Okay, next slide, Benji. All right, so I'm shifting gears a little bit here. And I was talking about the ARC Center for Future Planning, and there is the link down there, futureplanning.thearc.org. Great. Lots of great information on future planning and guardianship. And I pulled this one up particularly because it's for siblings, and it's really nice that the ARC of the United States is paying attention to the sibling role and how we really need to be supported in the future as we may take over those roles that our parents have done. So it talks about how, and here's why. One of the things that we have learned by working with siblings, actually in my own experiences as well, is starting that conversation with parents about future planning the whole gamut of future planning, special needs trust, social, all of that, where are they going to live, where are they going to work, has been extremely difficult for many, many, many siblings. And many siblings don't get the information about the plans that parents have made. A good friend of mine, their parents made plans, didn't put their information or their money in the appropriate trust, messed up funding forever for their brothers. And when the siblings did try and talk to their mom about what the plans were, mom wanted nothing to do with the conversation. That was my similar experience too. My dad wanted nothing to talk about, nothing about future planning and special needs trust, nothing. So this helps siblings walk through the steps. It sounds simpler than it actually is. Take a look at it if you're a sibling. Give it to siblings if they're struggling with this particular thing. Reach out to me if siblings are struggling, because we can be helpful in that area too. Go ahead, Benji. Okay, the future is now. So this is a really cool planning process, almost like if anybody's familiar with a letter of intent, but it's more detailed and there's a process to it. So you have 5 2.5-hour sessions with a professional or a mentor that kind of runs this group, and some of the things that they walk through with the individual and the family members. I had participated in this program many, many moons ago. They've changed the process, I think several times since then. And if you're interested in it, there is research out there on how well this program works. But some of the things in this document, which you'll get in the end of for the person with a disability, is they're going to talk about their dreams for the future. They're going to talk about and figure out ways to expand their social network, their support networks. Where do they want to live? Where do they want to work? Do they want to work? What do they want to do? Do they want to volunteer? Education, maybe they want to go back to school. What the retirement is going to look like? What's the retirement plan? And in the end, it comes together and talks about safeguards to ensure that the plan will be implemented, right? So what happens when mom and dad pass away? How can we ensure that this plan is still going to be implemented for the person? Now, when I did it by myself because it wasn't something that my brother could participate in. So it is something that you can come together with. My mom and we had this dream for my brother. We know what he liked and didn't like. So we were able to put that together in a document such as that. If you have any questions about this, please reach out to me. Either ask questions later or my email will be coming up soon. Go ahead, Benji. Losing my voice. Okay, so I promised I'd talk a little bit about the sibling. Well, I did talk about the Sibling Leadership Network. So they're like the Arc United States and like the Arc of Illinois, and we're like the Arc of Illinois. So they have a conference coming up, and I wanted to share all of this with people because I think it's really beneficial, really, for anybody, adult siblings. I originally attended, I think, the first conference. It was so awesome and amazing, because you just meet siblings from all over the place, all over the world, that you just have this connection, and we still talk to each other. But it's still really good. Is this a good avenue for parents and providers to attend some maybe sessions to learn more about the sibling experience? And I did mention it in the last presentation, but just to keep in mind, the SLN, the Sibling Leadership Network, just posted something about scholarships for individuals of color and of different economic abilities, basically, and they put it in a really lovely way, and they're trying to be as inclusive as possible, because honestly, on our siblings end, culturally, we are lacking, and connecting with all different people is really important to us. So if you have questions about that, I can get that information to you as well. Go ahead, Benji. All right, so well, we're getting to the end here. So these are our resources and the ways that you can connect with us, okay? So you can go to our website, join from that homepage link, our Facebook groups, our Illinois Adult Sibling Network. This Facebook group is just for adult siblings in Illinois, but SIBS Network is for adult siblings, parents, service providers, anybody who wants to know more about what we're doing and getting our resources and learning about our events that we're hosting or other organizations are hosting. We also have a LinkedIn account and a Twitter account. So whatever way is best for you to connect with us, those are our options. Okay. And I have to thank once again, and I know I did, but we are so grateful to the Illinois Council on Developmental Disabilities. They have allowed us to do this presentation today, many other presentations. I also am very grateful to the Sibling Leadership Network, because they partnered with us this entire time that we received the investment, and it really has helped us boost up the things for folks that we really have seen a lack in, which is siblings and supporting our brothers and sisters. So with, so one more slide. So you guys are going to get out early today, but I assuming there's going to be a lot of questions for Benji. Oh, one more slide, just with my info on it.
Sorry.
So thank you everyone for attending and being here. So with that, we're going to open it up to questions, I believe.
Yes, thank you both very, very much for all of the great information and resources. There's several comments about appreciation for your presentations and the information, and a few questions. So someone says, I had been filing guardianship yearly, but in 2019, after it was approved, I was told my next reporting would be 2021. Looks like DuPage may be biennial now. Is that for everyone?
Second. Sorry.
That's okay. Is DuPage every 2 years?
Yeah. So here's the thing. So a lot of counties have been. So a lot of counties will do every 3 years or every 2 years. The statute says it's supposed to be every year. It says that they can require one every year. It doesn't say you can require one any other amount of time. But whatever the judge wants to do, they could do. And so, I think that if they're saying if that's what the judge is going to do, then go along with what the judge is going to do. Does that answer the question?
I believe so.
Okay.
All right. Another person asked a few different questions, so I'll just break them down into one at a time. First of all, how hard is it to go from plenary to limited guardianship, or better yet, supported decision making?
It's a complicated process. You have to convince the judge that you tricked them. That's harsh. You have to convince the judge that either, which you don't want to be doing, telling them that you misinformed them and they didn't need a guardian in the first place. Or better, you'd have to convince them that things have changed. When we first did guardianship, they were, they had very significant support needs. And now, at this point, years later, they are much, much more independent, and they no longer need to have a guardianship at the level that they have now. And so we need to limit guardianship or completely remove the guardianship entirely.
Thank you. I hear that question a lot. I'm glad someone asked that. Second part of that question is—
And it's expensive too, by the way, especially if you're having an attorney do it, because it's very complicated. You have to convince the judge. It's a very sensitive thing to tell the judge that they were basically wrong before. So you really probably need to hire an attorney. It's going to be very expensive.
Okay, thank you. What happens when co-guardians do not agree?
If co-guardians don't agree, then you can't do anything. Co-guardian generally means you both have to agree to things. And so if you don't agree, then technically you're kind of at a standstill, which is why judges don't want to appoint co-guardians they don't think can come to an agreement.
Okay. What if the individual with the disability disagrees with guardianship and can adequately voice this to the judge?
It's up to the judge. They could go, every time you get a guardianship appointed, the judge, because the child will be there, otherwise, they're going to have a guardian ad litem appointed and all kinds of stuff. Generally, the child's going to be there and they're going to hand them a piece of paper, and it says that this is who you call if you ever are concerned about your guardians, don't want them to be guardian anymore, want a different guardian, think you should have guardianship anymore, and all of that. Remember, when they first became guardian, the child had to answer questions from the judge that said, are you okay with your parents being in charge of all your decisions? Or certain decisions if it's limited guardianship. So they already agreed to it in front of the judge. And now they say, no, I no longer agree to it. They need to tell the judge, and the judge has to be convinced that this is in their best interest.
Great. Very good questions. Another person asks, curious if adult children are notified if a spouse files for guardianship. In parentheses, you mentioned that adult siblings are notified when parents file. And again, thanks so much.
Okay, so let me just think this through. If a spouse files, I believe that parents, and if parents are alive, and the siblings would all get notification, but I don't quote me on that. I'd have to look it up, but I believe they would all be of equal standing to the spouse. So yeah, but I'm not positive.
Okay. I have an individual with co-guardians who will be moving into a 24-hour SILA setting from a less restrictive intermittent SILA setting. Will the co-guardians need to notify the court of this change?
What did they notify them in the first place when they moved into intermittent SILA?
Good.
That's the first question.
Yeah.
Probably not, is my guess. But if they, either way, they probably should. It's, again, it depends on the judge and if they're going to enforce it or not. I think at minimum, so my legal answer is they should. Yes, they should tell the judge. Practically, a lot of parents might basically take the risk and put it on the annual report where they now live, and they now live in a full shift SILA and like in a 24/7 SILA. They might take that risk and just put it on the annual report and see what the judge says. But the legal answer is that they really should be getting it approved by the judge.
Okay. What is the process of going from a single guardian to co-guardianship? What steps have to be taken? Who must be involved?
It's certainly easier. It's not doing a guardianship. It's not convincing a judge that they need a guardian. It's just making sure that the judge feels that these two individuals can agree on things and work together, and that they'd be a good person to be guardian and have the best interests of the ward at heart. They're going to want to meet, obviously, the new co-guardian, and also they're going to probably want to have the ward, the individual with disabilities, also there. So they could say, yes, this person would be fine to be my co-guardian. And then the co-guardian, the judge can ask questions of to make sure that they're the right person.
Great. One or two more, it looks like. This one says, my wife, who's a non-guardian, and I will be making our wills out soon, hopefully in the summer. In that process, that's where we would designate a successor guardian for my brother, correct?
So one of your parents is guardian, one is not guardian. That's what I'm reading from that. The parent who is guardian actually nominates, has the nomination. The thing, though, is that if there's another parent living, they have precedence over a sibling by default. The parent who is guardian should nominate presumably the other parent, if that's the appropriate choice, to be guardian. And then if they're both gone, then the will would nominate, who the successor guardian. But really, if for some reason only one parent is guardian, but we expect the other parent survivor, if they survive, to be guardian after them, we'd want both wills to nominate guardians after the second of them die, to cover our bases.
Okay. There's a second part to that and asks, is that the same for successor trustee and representative payee for SSDI?
Totally different worlds.
Okay.
Trustees have nothing to do with the wills. Trustees are in the special needs trust itself. It'll name successor trustees or a method for naming successor trustees. Social Security, you have to do a new interview for the new representative payee of who should be in charge.
Very good. There's a couple follow-ups, but I think to the questions before, I think you may have touched on it though. Back to the person who moved from intermittent to 24-hour. The individual did not have co-guardians at the time they moved into intermittent.
Okay, got it. So yeah, so you're supposed to, because this is a change of circumstance that you have to tell the guardian, the judge about. So yes, you're supposed to do it. Again, most people probably don't, but it's pretty clear in the law you're supposed to do it.
Okay, excellent. How does a sibling get guardianship if the individual doesn't want a guardian? The comments after that say police have been called out, the person has behaviors and really shouldn't be their own guardian, what this writer says.
All right. So that's going to be what they call a contested guardianship. There's two forms of it generally. The two common ones are where like divorced parents fight over who should be guardian. And the other is where the individual themselves, the ward, as we call it, or the potential ward, doesn't want a guardian, or doesn't want the people who want to become their guardian to be their guardian. And in either case, it's a contested guardianship, and it's going to come down, they're going to appoint a guardian ad litem, almost certainly, to investigate, both sides of the issue, whether or not they need a guardian or don't need a guardian. In this circumstance, they're going to interview the individual, interview the parents, assuming the parents are the ones who want to become guardian. And then they're going to report back to the judge, and then it's going to be up to the judge. The judge can have witnesses. It basically becomes a trial. The cost of a contested guardianship can easily exceed tens of thousands of dollars because it's very, very labor intensive for attorneys. There's going to be multiple hearings, potential witnesses called, cross-examination. Again, the guardian ad litem is going to be appointed. They're going to charge, anywhere from $500 to $2,000 in addition to all of this. So it's a very expensive process to do that, a contested guardianship matter. We really seek to avoid those, but it could be anywhere from $7,000, $8,000 to $15,000 or $20,000 or more. I mean, the sky's the limit with them if it gets really, really complicated and really contentious. Because they're also going to appoint someone to represent the individual, the individual disabilities as well, who's also going to have to get paid.
Okay, so Benji, if this person has a history of interacting with the police, does that help them with the case of needing a guardian?
Sure. All this is going to be evidence.
So maybe it wouldn't be as costly if they've got, tons of police reports.
It's tons of police reports, and it's also just kind of it's the police reports, it's a doctor's reports, psychiatrists. That's going to be really, the judges love psychiatrist reports. They really view those is very important for them. And so if the psychiatrist report's really good, and the guardian ad litem report, because they're going to want to interview the child, disabilities, if that report is really strong, if all that is together and all point the same direction, all we really have is an individual who clearly cannot make their own decisions, but is just refusing, just saying they don't, or just, refusing the guardianship, but clearly they need it. And no professional is going to disagree, and no third party would ever disagree, then yes, it would get a lot less expensive. It's still going to be more expensive than a traditional guardianship, because there's going to be due diligence that has to be done. You have to pay the guardian ad litem fees, but it would probably, now we're probably talking a less than $10,000 situation, but certainly more than a few $1,000s, definitely, to do that.
Well, thank you very much. Looks like right now there's two more questions.
Okay.
I live in Kane County. My 19-year-old with autism has agreed to allow us to have power of attorney for health and finances and I believe education. He said this would be difficult. How should I proceed?
Wait, it would be difficult to have be power of attorney?
I think that's what the question is
Yeah.
referring to.
So powers of attorney, no, it's very easy. They just, I mean, you want to have an attorney that knows what they're doing, draft the powers of attorney to add the extra powers that should be in there, especially for the property power of attorney. And if there's any other powers of attorney, the Social Security, Medicaid, you know, forms, all those should be filled out correctly. But it's not complicated. It's just, or it's not difficult, I should say. You know, they just have to sign them. It's really straightforward. It takes, you know, 10 minutes for them to sign the powers of attorney. They just have to be drafted correctly. It's guardianship process that's difficult. The powers of attorney are relatively easy.
Great. That was very helpful to that writer. Looks like one more. If there's others, I invite people to get them in the chat now.
Yeah.
The last one says, how much does a basic guardianship quote lawyer fee run? Full guardianship, for full guardianship.
It shouldn't really matter co versus individual unless the parents are divorced and there's a, you know, could be contested. But in general, if everyone's on the same page and it's like mom and dad want to become co-guardians or siblings want to become co-guardians, there's nothing weird going on. Then you know, the cost, it depends on the experience of the lawyer that you hire, basically, or if you do it on your own, it's just the, you know, $300 to $400 of court costs, depending on what county you're in, maybe a little less than that. But it's pretty substantial now. They keep increasing those fees. But if you hire an attorney, the costs can range from less than $1,000 to a very inexperienced attorney, to thousands of dollars for a more experienced attorney to do it. If you're hiring an attorney that does it day in and day out, it's going to be a few $1,000s. You're going to be talking about, yeah, and that kind of range. And again, everything in between. Someone who does it sometimes, occasionally, you're talking about between probably $1,000 to $2,000. More often, $2,000 to $3,000. Someone who's extremely experienced, it's going to be, you know, close to that $3,000 or so. And this is again for just plain vanilla plenary guardianship. If it's a limited guardianship, it's going to be more complicated and more expensive at each of those levels.
Great, thank you. There may be one more, maybe two. In the case that there were concerns about guardians' ability to carry out their duties, care for their ward, what are some steps an adult sibling could take?
So it's difficult, as parents may lose capacity as they get older. At what point they should be stepping down in favor of a sibling. It's a very awkward conversation. They could try and, you know, nudge or lightly suggest becoming a co-guardian, see if that'll work, if the judge will permit that. Sometimes the judge will look at it and say, okay, the parents are in their 80s, you know, it's time to, you know, having a sibling as a co-guardian makes some sense now, even though it's a third co-guardian, they don't usually like that. So that might be a way to kind of get yourself into it, and without the parents feeling like they've been, you know, stripped of that authority. That's kind of what I would look to do, because you don't want to have a contested thing about, you know, kicking them out unless it gets to the point where they're actually really are, it's a danger to that child, and then you may have to go to that route, but you destroy the relationship with those parents potentially.
Thank you. What are requirements for plenary guardian moving from Cook to DuPage County?
Well, first of all, whether you have to move it is up to the judge, even if they didn't, the ward did move. But it's just, you know, it's a process of, you know, basically establishing the guardianship in DuPage County, telling the Cook County judge about it and getting it transferred over. It's not nothing. It requires two different hearings, one hearing to basically kind of close out what's going on in Cook County and open up what's going on in DuPage County. So you know, that's basically the process. They don't really ask about cost, but the cost is gonna probably be a couple $1,000s again, because you're doing, you know, you're having two different court hearings and all of that, and paperwork in two different counties. Even though it's not opening up a fresh guardianship, there's still a lot of work associated with it. But again, if you have an inexperienced attorney, maybe they'll do it for under $1,000. Again, it all depends on how experienced the attorney is, and you know, and that's obviously going to impact how well everything's done and that every I is dotted, T is crossed and all that. But yeah, that would be the process.
Thank you. Good information. How difficult is it for a family to complete the guardianship process without an attorney?
It really depends on the county. Some counties, the clerk's office are very, very helpful. Some they're not as helpful. So if you're the clerk in your in your court is really nice and generous with their time, then they can probably make it work. It is time consuming. There's a lot of paperwork, a lot of stuff to fill out, and just to learn, you have to basically learn it yourself. What do I have to fill out? When do I have to fill it out? How do I fill it out? What's step 1, step 2, step 3? You basically have to learn it yourself and teach yourself. It's not complicated. It is not rocket science. It just, you have time. It's time. So if you're someone who has the time in your hands and wants to save some money, it's definitely doable, and it's easier in certain counties than other counties, depending. The only costs you'd have are just the court fees, the few $100s in court costs.
Okay. Thank you. One is a clarification question. The person is asking, did I hear correctly that the ward cannot have a driver's license?
If it's a plenary guardianship, so if it's a full guardianship, then absolutely they cannot have a driver's license. The driver's license is void. If they have one, and if they apply for one, they're applying for it illegally. It's a big, big problem. They cannot have a driver's license. But if it's a limited guardianship, then they could have a driver's license.
Thank you. What is the best place to find power of attorney forms?
You can Google State of Illinois Statutory Power of Attorney forms. But again, when it comes to to a power of attorney for healthcare, the statutory form should be fine as long as you can figure out what you're supposed to be, which box you're supposed to be initialing, which you might need some guidance on. But the financial or property power of attorney, that one you do not want to just fill out the form online. You're going to want to add a lot of extra powers to it, to deal with an employer, to deal with a job coach, deal with residential matters, to deal with tax matters, things that you're not going to find online on the statutory form. That you're going to see there, or something that LegalZoom is going to sell you, on their national kind of plug-in in State of Illinois form. So that's why you're going to want to hire an attorney to do that. But the healthcare one, you could really just get online as long as you can follow the instructions and understand which box you should be initialing for each thing.
Great. 2 more. What does Illinois say about a guardian who suddenly passes away and no successor guardian has been named?
So, well, basically, if there's no guardian appointed, then someone has to petition. Usually it's going to be the agency where they're living, for example. Someone has to petition for the State Public Guardian's Office to step in. Or if there's a trust, a special needs trust or something like that, then they hire a nonprofit organization to petition for them to step in, or for profit for that matter, but generally nonprofit. That would basically be what would happen. If no one petitions, there's no guardian, it's kind of a mess. But at some point, someone would presumably petition for at least a state public guardian to take over. But it can't happen until someone petitions for it.
Okay. Okay. The last one is a point of clarification and a question. The person thought they understood this, but she says, you don't need power of attorney if you are doing guardianship, correct?
Correct. See, guardianship is it's basically it's an either or proposition. Either your guardian or your power of attorney. You really shouldn't be. You really can't be both. Guardianship is in almost all cases, with a few exceptions, more powerful than a power of attorney.
I've never
But
actually.
the second part of that, can co-guardians who are divorced parents with a good relationship outline which one makes financial decisions?
No, the judge, the judges aren't going to allow you to split up areas of the guardianship between co-guardians. No, they're going to want both of you to have authority over it. Now, when it comes to the trust, the special needs trust, that obviously you can spell out however you want. But in terms of, the guardians being in charge of kind of the bank accounts, of who's in charge of their work earnings or something, that's the judge is going to want to split that up between which guardian does what. Of course, what kind of money do they have in their name? They really, presumably don't have that much money in their name, just work earnings. And Social Security only can have one person in charge, the representative payee. So that really might be a moot point as to who's in charge of financial decisions between two co-guardians. If the representative payee is in charge of Social Security, all that's left is just work earnings. And then, yeah, the judge isn't going to want to say who's in charge of that or not.
Great. Thank you so very much. It looks like that wraps up all of our questions. I'm going to invite Catherine to come on. Catherine is a program director here at Ray Graham Association, and Tara referenced her earlier, and she's just going to do a little wrap up for us. So, Catherine, when you're ready, come on.
Yes, hello. Yes, Tara had to tell everybody how old I am. No, I started when I was at CSS when I was 18, Tara. That's when I met you. I'm so very young. I did want to thank everyone for attending one of our sessions today. And of course, I wanted to thank Tara CONLEY and Mr. Benji Rubin as well for all of their help and assistance. Erin will be sending out the slides, the presentation, as well as links to some of the forums that you're asking about. And also, she's going to post right now in the chat again that if you need CEUs, because it's 2 CEUs, to make sure you that you click on the link. Oh, she just put it there. See the link for the survey. You need to complete the survey in order to receive your CEUs for attendance. So please click on the SurveyMonkey link that she just put in the chat right now. So again, thank you so much, Benji. Thank you so much, Tara. And thank you everyone for attending today. We really appreciate it.
Thank you.
Thank you.
Thank you.
Thank you, everyone. Have a great day.
Thanks. Be well.